The same Roland Diaz, who was placed on community supervision in 2021 CR 1482 for the offense of robbery on June 2nd, 2021 for a term of 8 years. Is that you?
Yes, ma'am.
All right, state 063B, State of Texas versus Roland Diaz. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense.
Good morning, Frankie Sandoval on behalf of Mr. Diaz.
All right, are you Roland Diaz? All right, counsel, have you received all the discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Diaz, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we're proceeding on count 1 and waiving count 2.
Any objection to the waiver?
No objection, Judge.
Mr. Diaz, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand in count 1, you're charged with the offense of aggravated robbery? That's a first-degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
This is where everything begins, and it moves fast. We're in a Texas courtroom where Roland Diaz is facing a first-degree felony, aggravated robbery. That alone carries a potential life sentence. But here's the twist. He's not going to trial. He's about to give up his rights, accept the deal, and trust the system to go easy on him.
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do believe so, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
In my opinion, yes, Your Honor.
Mr. Diaz, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to plea, punishment is to be assessed at 20 years in the prison. The state is proceeding on count 1. There's an affirmative. Well, if I find that there is a deadly weapon, do you understand that the court will enter an affirmative finding of deadly weapon?
Sure.
The state will run this concurrent with 2021 CR 1482, taking consideration 2023 CR 9065A, 2023 CR 9064B, and 2023 CR 9066A. Did you understand that was the plea? State, is that the plea?
Yes, Your Honor.
Defense, is that the plea? Affirmative finding of deadly weapon. No problem. Did you review the paragraph entitled Waiver of Appeal paragraph with your attorney? Oh, they need to initial. Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
There have been motions, Your Honor, but none ruled upon.
Then to the offense as charged in count 1, how do you plead? Guilty, not guilty, or no contest? I'm sorry?
No contest.
State any evidence to support the defendant's plea?
See it all proceeds to the one and all attachments.
Any objection?
No objection, Judge.
State, you may continue to confer. Going to show you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Sure.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you?
There's no live testimony, no witnesses, no cross-examination. Instead, the case is decided on documents, police reports, and written statements alone. That means the judge is acting as the sole evaluator of evidence. No jury, no emotional appeals, just cold legal review. And once the judge says there's sufficient evidence,
Understand?
Yes, ma'am.
The court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor, in the interest of justice.
All right, the court will find you guilty, sentence you to 20 years in the prison, give you credit for any time served. There's an affirmative finding of deadly weapon. This will run concurrent with 2021 CR 1482. Take in consideration 2023 CR 9065A, 2023 CR 9064B, 2023 CR 906AA. There's to be no contact with Cornelia Childress, Demetrius, Demitresse, Erkson, Erskion, Tiffany Hernandez, Richard Montalongo, Karen Salazar, or any cricket store. Anything else with regards to sentencing?
That would restrict the sentences, Your Honor.
Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we're now going to proceed in 2021 CR 1482. Did you review the documents entitled, I need a person from the state? Did you review the documents entitled Motion to Revoke Community Supervision and First Amended Motion to Revoke Community Supervision and Second Amended Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Roland Diaz who was placed on community supervision in 2021 CR 1482 for the offense of robbery on June 2nd, 2021 for a term of 8 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 1, on or about the 21st day of October 2022 in Bexar County, Texas, the defendant, Roland Diaz, committed the offense of aggravated robbery in violation of condition number 1.
How do you plead to that? True or not true?
True.
Your Honor, the state waives all the violations.
Any objections to the state's waiver?
No, Judge.
All right, and on this one, I need a trial court certification.
I'll get you one, Judge.
All right. Mr. Diaz, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1? I'm sorry?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there an agreement?
Yes, Your Honor, 10 years TDC.
Is that the agreement, counsel?
It is, Judge.
Mr. Diaz, are you asking the court to follow that plea?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right, then the court will follow your plea. The court will grant the motion, revoke you, sentence you to 10 years in the prison, give you credit for any time served. This will run concurrent with cause number 2023 CR 9063B.
another defendant tries a completely different strategy. Emotion, sympathy, redemption. His girlfriend defends him. He admits his past, promises change, but the judge isn't buying it. When she turns to the girlfriend and says, "Back-end index pointing right, you're not being a good parent," that's not just criticism. That's a full rejection of their entire narrative. You can feel the courtroom freeze, because in that moment, it's clear. Back-end index pointing right, the judge sees through the performance.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Thank you. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, Mr. Diaz, you're going to have to start making better choices. You understand?
Yes, ma'am.
All right, good luck to you.
This case wasn't just about robbery or addiction. It was about accountability versus excuses. Roland Diaz took a deal and locked in 20 years. The second defendant gambled on sympathy and got the maximum 10 years instead. Two different strategies, same outcome. Prison. The lesson? Back-end index pointing right in court, credibility matters more than emotion. And judges are trained to spot the difference instantly. If this courtroom moment shocked you, hit like, share your opinion in the comments, and subscribe for more